Welcome to Removal Proceedings 101, Understanding the Rules. My name is Vicki Giambra, and I am a senior staff attorney with the Children's Immigration Law Academy, or CILA. This 101 webinar is being recorded on March 4th, 2022. It is one of a series of webinars we have available for advocates who are new to the field of children's immigration law. We will cover the basics of removal proceedings in immigration court with a special focus on how children and youth are treated. Please note that immigration law changes rapidly. It is important to stay up to date with case law, policy changes, and any procedural changes. CILA is a project of the American Bar Association. We are part of the Commission on Immigration, and CILA is a legal resource center. We aim to build the capacity of legal service organizations and pro bono attorneys to represent children facing deportation. There is no right to appointed counsel in immigration court, even for children, and we believe every child should have an attorney at their side in immigration proceedings. In Texas, CILA provides individualized technical assistance, which can be requested by any attorney representing a child or youth in their immigration case. We also offer regular trainings, resources, and the opportunity to collaborate with other attorneys and legal staff through working groups. Recently, we started a social work program to support social workers and social services staff working at the legal service organizations in Texas. Nationwide, we support pro bono programs through a pro bono initiatives project, which includes a pro bono platform, Pro Bono Matters for Children Facing Deportation. We offer free resources on our website, cilacademy.org, including a detailed pro bono guide that details how to work with children and youth in their immigration cases. So today we're going to be looking at various aspects of removal proceedings. First, we will start with the history of immigration court and the law governing the courts and removal proceedings. Then we will move on and talk about procedure, how removal proceedings work and what to expect when you're in immigration court. Next, we will talk about how evidence is handled in immigration court, as it is a bit different than maybe you're used to with the federal or state rules of evidence. Then we will tie it all together by looking how the immigration courts handle children's cases in particular. So a little bit of background about the immigration court. The court, as we know it today, is an administrative department of the Executive Office for Immigration Review, which is a branch of the Department of Justice. There are close to 400 immigration judges around the country and 63 immigration courts. The immigration courts, it is interesting to note, are not Article 3 courts. So what does this mean? This means that immigration judges are administrative judges hired by the Department of Justice. They are not elected like some state judges or appointed and confirmed by Congress like some federal judges. Their powers and authority are delegated by the Attorney General and limited by his or her regulations. So, there's three different types of courts in the United States. The ones that we're mostly used to are Article 3 courts. These are the federal courts. So your district courts, circuit courts, and the Supreme Court. Article 1 courts are courts that were created by the legislative branch. So these would be bankruptcy courts and tax courts. And Article 2 courts are courts that are created by the executive branch. So immigration judges are slightly different because they're part of the executive branch and they don't have the same level of judicial independence as we're used to in our other judges. So I'm going to provide a brief history of immigration court to help you understand the context of how we got from the picture on the left, which is the Board of Special Inquiry on Ellis Island, to the EOIR courts that we know today. Much of the information on this presentation came directly from the EOIR website, along with a law review article published in Notre Dame Law Review in 2006. When our immigration system first started, there were not many procedural requirements. As I mentioned, the previous picture is from the boards of special inquiry at Ellis Island. These were created in 1893. An immigrant seeking admission to the United States would go through a first inspection when they arrived. And if the officer didn't think they should be admitted, they were referred to this board of 3 officers. These officers were the same people that worked as inspection officers, which meant that from the get-go, they kind of have a law enforcement mentality rather than a judicial or adjudicator mentality. It was a closed hearing that could be appealed to the Secretary of Labor. A special inquiry officer represented the government, and only in complex cases would another officer present the government's case, which meant there was no distinction between the adjudicator and law enforcement. The process has evolved over 60 years, but there were significant concerns about due process. When the creation of the Immigration and Nationality Act happened in 1952, there was a statutory provision of that called for special inquiry officers to oversee excludability proceedings, which had more statutory and procedural requirements than before. So the special inquiry officers could subpoena witnesses. The immigrant could bring a friend or a relative. There had to be a record of the proceeding. It was required. And the service could have an officer to represent them and present evidence and to cross-examine, etc. This was a significant change. It was the first time that they bifurcated the decision maker from the law enforcement officer. But despite these advances, the new structure did not address that the court structure or its relationship to the Immigration and Nationality Service, which is where it was housed. Proceedings gradually continued to evolve into what the Immigration Court is today. In 1973, the special information officers were given the title immigration judge and allowed to wear robes. More qualifications were required to get the job, and the position of chief special inquiry officer was created. In 1983, the Department of Justice created the Executive Office for Immigration Review, or EOIR, also referred to as EOR. And it housed the Office of the Chief Immigration Judge and the Board of Immigration Appeals. However, these agencies were still within the Immigration and Nationality Service. In 1997, when the Illegal Immigration Reform and Immigration Responsibility Act was implemented, it revised the system of deportation and exclusion. We got removal proceedings instead, and many of the rules and procedures that govern immigration court today came from IRA. Immigration judges got contempt powers, but regulations were never issued by DOJ because it would allow for contempt against a sister agency within the DOJ. Again, it highlighted the conflict of interest of having the adjudicator and the prosecutor housed in the same agency as they had always been. Then in 2022, after September 11th, the Department of Homeland Security was created by the Homeland Security Act of 2002. And it codified EOIR's separation from the Immigration and Nationality Service. In fact, it abolished the Immigration and Nationality Service and transferred INS's immigration enforcement and immigration benefit functions to the newly created Department of Homeland Security and maintained their Attorney General's authority over EOIR. So that's kind of the last big change in immigration court. So for those of you who are more visual, here is an organizational chart for the current Department of Justice. You can see the Executive Office for Immigration Review, called EOIR or EOR, in the pink circle on the right-hand side. So this is a representation of EOIR's current organizational structure. So there's finally got some independence, but from the Immigration and Nationality Service, which was transferred over to the Department of Homeland Security. But it's important to remember that there are still constraints to achieving the mission of EOIR. So the primary mission of EOIR is to adjudicate immigration cases fairly, expeditiously, and uniformly, interpreting and administrating the nation's immigration laws. The Attorney General is still the head of EOIR, so he's still the head of the Board of Immigration Appeals and the Immigration Court. The Attorney General has influence over substantive and procedural outcomes in the BIA and the Immigration Court. One example is certified cases from the BIA. The AG can certify cases to himself, cases that influence the ability to get continuances or administrative closure. Another example is that they can influence how the Attorney General can influence how court dockets are handled with case quotas, case priorities, rocket dockets, etc. This is why many professional organizations, such as the American Bar Association and the National Association of Immigration Judges, have lobbied for a more independent structure for the immigration court system. Okay. It can be helpful to know the history of immigration courts so that we acknowledge that we are working in a system that is not a typical court setting. Where do you go today to determine what the rules are for filing a motion, meeting a deadline, giving notice of a filing, standard of proof in your case, getting a final hearing, or asking for continuances? There are many different places to go to find this information. And here I'm providing a list of some of the most common sources. These include statutes, regulation, and case law. Not only do the federal courts have some ability to review immigration cases, but the BIA also creates both precedential and non-precedential case law that applies in all jurisdictions regarding immigration court procedure. Other extremely valuable resources are the Immigration Court Practice Manual and policy memos issued by EOIR. The Immigration Judge Benchbook is also available for an understanding of any internal rules that apply to immigration judges. Also beware there are specific ethical rules created by EOIR. This is not going to be an exhaustive presentation of all the laws, but rather highlighting ones that we think are most relevant to your practice. So now that we know where to find the laws relating to immigration and removal proceeding, let's dive into immigration court procedure. We'll talk about how removal proceedings begin, what rights immigrants have in removal proceedings, the typical path that a case will take, and the burdens and standard of proof required. Proceedings in immigration court begin when the charging document, also called a notice to appear, or NTA, is filed with the immigration court by the Department of Homeland Security after it has been served on the individual. Generally, the NTA is a charging document that goes over the charges against the individual, why they are in immigration court. It includes the law and the relevant facts in that particular case. There's a really good practice advisory from the American Immigration Council on NTAs to give you a bit more information. So jurisdiction vests with the immigration court when the charging document is filed, with the exception of bond hearings. On occasion, an initial hearing is scheduled for an individual before the Department of Homeland Security, DHS, has been able to file a notice to appear with the immigration court. For example, DHS may serve a notice to appear which contains a hearing date on an alien, but not file the notice to appear with the court until sometime later. Where DHS has not filed the notice to appear with the court by the time of the first hearing, this is known as a failure to prosecute. If there is a failure to prosecute, the respondent and counsel may be excused until DHS files the notice to appear with the court, at which time a hearing is scheduled. Alternatively, at the discretion of the immigration judge, the hearing may go forward if both parties are present in court and DHS files the notice to appear in a court hearing. The NTA as a charging document includes identifying information, the factual allegations against the individual, the charge against the respondent, and proof of service. INA 240A2 says that an immigration judge shall conduct proceedings for deciding the inadmissibility or deportability of a respondent and is the sole and exclusive procedure for determining admissibility or removability. This alludes to the fact that there are two types of proceedings that determine whether or not an individual can stay in the United States. Inadmissibility proceedings, which are predicated on the grounds of inadmissibility in INA 212, and are things that would make somebody unable to enter the United States. Deportability proceedings involve the grounds of deportability in INA 237, which are things that would allow the government to remove somebody from the United States after they were admitted. So immigrants have several rights when they are in immigration court. The first of which is a right to representation by counsel. So all immigrants have a right to representation in immigration court, but at their own expense, not at the expense of the government. This allows that it is allowed for attorneys, law students, law graduates, and BIA accredited representatives to represent people in immigration court. And there can be multiple representatives of one person. But the important thing to know is that you have a right to representation, just not for free. You do have to pay for it. There is also a right to a list of legal services, which is updated quarterly. This is in a Regulation 8 CFR 1003.61. And this includes nonprofit organizations that represent immigrants in court, as well as for-profit immigration attorneys. There is also a right, when you have been put in removal proceedings in immigration court, to contact your consulate. A detained foreign national must be notified that he or she may communicate with the consul or diplomatic officer of their country. This is in 8 CFR 1236.1 of our regulations, and also corresponds with Article 36 of the Vienna Convention on Consular Relations. Other rights are a right to interpretation or translation. This is somewhat contested. The Federal Court Interpreters Act of 1978 requires the use of interpreters in federal proceedings, whether civil, like immigration court, or criminal. There's also an executive order, 13166, and Title 6 of the Civil Rights Act, which requires federal agencies to grant limited English proficiency individuals meaningful access to their programs, which would include immigration court. Any interpreter in a hearing must be sworn to interpret accurately, but it is uncertain as to whether a person in removal proceedings who does not understand English has a right to the interpreter. In 2019, the Department of Justice told immigration judges that interpretation would be cut for master calendar hearings, and it produced videos to give the advisals that immigrants have a right to. Subsequent to this, investigative reporting revealed that the Trump administration had miscalculated the numbers that led them to decide to cut the interpretation budget. So there is some controversy as to whether or not there is a right to interpretation in immigration court. However, there is no right to the translation of documents at the government's expense, and that's in 8 CFR 1240.5. The other right that another right that immigrants have in immigration court is the right to examine evidence. They INA 240B4B says that immigrants should have a reasonable opportunity to examine evidence against him or her, and to present evidence and cross-examine government witnesses. Another right is the right to be advised of eligibility for relief. These are the advisals I was speaking about in the when I was talking about interpreters. 8 CFR 1240.11A2 says that the immigration judge shall inform the alien of his or her apparent eligibility to apply for any benefit enumerated in this chapter, and shall afford the alien an opportunity to make an application during the hearing. Possibly most importantly of all, every person within the United States, including immigrants, has a right to due process. This is part of the Fifth Amendment, which says no person shall be deprived of life, liberty, or property without due process of law. And it says person, it does not say, US citizen. So it's any person, regardless of their immigration status. There have been many cases that have affirmed this right to due process in immigration proceedings, including the opportunity for a full and fair hearing. However, there is something to be aware of, that even though you have an opportunity for a full and fair hearing and a reasonable opportunity to present evidence, and due process does apply to immigration proceedings, you do have to show that there was prejudice to prevail on a due process challenge in immigration courts. So children have some slightly different rights or benefits, I suppose, in immigration proceedings. The first of which comes from 8 CFR 1240.10c, and it says the immigration judge shall not accept an admission of removability, but an unrepresented respondent who is incompetent or under the age of 18 and is not accompanied by an attorney or legal representative, near relative, legal guardian, or friend. So if a child is in immigration court, say, for example, he was brought by the Office of Refugee Resettlement, but there is no attorney there, there is no parent there, then the judge is not able to accept an admission of removability from this child because they are under 18 and are not able to have the scienter, I suppose, to make that admission. Also, the INA in INA 240B4B recommends various child-friendly immigration practices. And this is also corroborated by the Immigration Court Practice Manual and EOIR OPPM 17-03. EOIR OPPM 17-3 replaced an earlier memorandum from 2007, but it applies to any case involving an unmarried individual under the age of 18. They do not have to be an unaccompanied child. Unfortunately, in the 2017 memorandum, they removed the best interest of the child standard, and it can no longer be used by the immigration judge. It weakened some child-friendly practices, but and omitted guidance regarding the use of age-appropriate language and tone. It seems to indicate that judges should use the same standards when evaluating the testimony of children and adults. That also de-emphasizes developmental and capacity differences between children and adults. There is an emphasis on rooting out fraud in unaccompanied children cases, and it uses the term illegal alien. This memorandum has not yet been replaced by the current administration, despite their directive not to use the term illegal alien. However, the Immigration Court Practice Manual does recommend that immigration courts do their best to, for example, schedule cases involving unaccompanied juveniles on a separate docket or at a fixed time. And that it does tell you that an immigration judge cannot appoint a legal representative or a guardian ad litem for an unaccompanied juvenile, but they do encourage the use of pro bono for these children. And then it also discusses courtroom orientation, and it says that juveniles are encouraged under the supervision of court personnel to explore an empty courtroom, sit in all locations, and practice answering simple questions before the hearing. ORR does provide an orientation for most juveniles in their native languages, explaining immigration court proceedings, and that the judge is allowed to make some courtroom modifications. They can allow juveniles to bring pillows or toys. and to sit with an adult and allow children to sit with an adult companion, and also testify outside of the witness stand next to a trusted adult. And it also allows for the immigration judges to remove their robes to make it more child friendly. So how can an immigration removal proceedings proceed? So basically, their INA 240B2 gives several ways in which a case in immigration court can go on. The first is what we would expect in person. The second is by video conference. There is also an option for a telephone conference, except that evidentiary hearings on the merits may only be held by telephone if the respondent consents after having been notified of the right to proceed in person or have a video conference. Interestingly, it doesn't have this same caveat for video conferences. It appears that EOIR feels that in-person conferences, in-person hearings and video conferences are comparable. There is also a ability for the immigration judge to waive the respondent or the respondent attorney's appearance at specific hearings. This happens frequently for children, especially if they're with an adult, that the immigration judge will waive the child's appearance at master calendar hearings going forward, especially if the child is in school. It is possible to have an in absentia hearing, so that if somebody is scheduled for a hearing but they do not arrive and do not and therefore are not in person, they are not appearing via video conference or telephone, then they will have an in absentia hearing and can be removed, ordered removed in absentia. Okay. Generally, removal proceedings or hearings in immigration court are open to the public, except for evidentiary hearings involving asylum, withholding, CAT, or other cruel, inhumane, degrading treatment or punishment. They are open, those are open to the public unless the respondent expressly requests that the hearing be closed. Generally, though, hearings involving abused children and abused spouses are closed unless the abused person agrees that they can be open to the public. Any information that may be considered subject to a protective order or was filed under a seal in the immigration court would also cause the hearing to be closed to the public. The IJ is authorized to close or limit attendance at any hearing to protect parties, witnesses, or the public interest, even if the hearing would normally be open to the public, and that's in 8 CFR 1003.27. News media may also attend hearings that are open to the public, subject to the general prohibition on electronic devices in the courtroom. There is a record that will be made, and you can see more details on this in Immigration Court Practice, the Immigration Court Practice Manual, Chapter 4.10. Hearings are recorded electronically by the immigration judge, and it is transcribed when any appeal is made to the Board of Immigration Appeals. The official file containing any documents relating to the person's case is called the Record of Proceedings, and it is created by the Immigration Court. And it is available for, it is possible to see this Record of Proceedings. The old paper files that were at the court, you can go and request from the court to see it, either in person or through a FOIA. And now EOIR is moving to an online system, and the Record of Proceedings will be created electronically. Like we discussed earlier, interpreters are actually provided by the immigration court at the moment. The Immigration Court Practice Manual indicates that interpreters are provided at the government expense at master calendar hearings and individual hearings. Courtroom decorum. Something to be aware of are the various ways that immigration court runs. I'm sure if you are a litigator and you've practiced in other areas like family court or bankruptcy court or just regular state and federal courts, you know that there's a certain way that judges want you to behave and want your client to behave. So children who are in immigration proceedings must attend all scheduled hearings unless their appearance is waived by the immigration judge. Children not in proceedings should not be brought to court. If a child disrupts the hearing may be postponed with the delay attributed to the party who brought the child. This can be difficult if the child you're working with is with their parent and the parent comes to court and they have younger children who are perhaps US citizens and not involved in the immigration proceedings. It can often be difficult, but you need to encourage them to find somebody to watch the children. As far as electronic devices, only the immigration judge may record proceedings. No device of any kind may be used by any other person to record any part of a hearing. And that's in 8 CFR 1003.28. You may keep cell phones, laptops, and other electronic devices that are used to conduct business in your possession, but cell phones must be turned off and other devices must be set to silent mode or turned off. During a hearing, you may use electronics such as laptops in silent mode, but it must not disrupt the hearing. So if you're the attorney, for example, you may use these electronic devices, but not to disrupt the hearing. You can find more information about electronic devices in immigration court in EOIR Policy Memorandum 19-10. So one thing that happens in immigration court that is very different to what might happen in any other court you may have seen is comes in INA 240B1, where it says the immigration judge shall administer oaths, receive evidence, and interrogate, examine, and cross-examine the alien and any witnesses. This empowers the judge to do direct examinations on your client, and many judges do. They will interrupt your line of questioning and answer and start asking questions of your client themselves. And they won't ask you permission to do so. They will just, they oftentimes just interrupt and start talking, which we know can disrupt our flow as attorneys and what we've practiced with our client. So it's a really good idea to prepare your client for the fact that this might happen. And also be very, pay close attention to when this happens so that if you need to ask different questions to undo kind of any negatives that may have come out while the judge was questioning. Okay, so the first step in immigration proceedings is called the master calendar hearing. And this is a short preliminary hearing before the immigration judge to determine how the non-citizen's case will proceed. There may be more than one master calendar hearing scheduled in a case. The immigration judge will, during this master calendar hearing, identify the non-citizen's name, address, telephone number, and case number, the date and place of the proceedings, and the presence of the parties. So he will go on the record to do all that. He will then explain the non-citizen's rights in immigration court and address any issues pertaining to representation. Then they will confirm that the notice to appear was properly served and provide the non-citizen with the opportunity to admit or deny any factual allegations in the NTA or concede and to concede or contest the charges of removability. At that point, if that has happened, the judge will determine if removability has been established. And if it has, they will provide the non-citizen with the opportunity to claim their defenses and or seek relief if removable. Then they set a date for the individual hearing and resolve the case if possible. So there's a couple things here in that not all of this necessarily happens in one master calendar hearing. That's a lot of things to happen in one master calendar hearing. So the scope of the master calendar hearing is laid out in the INA and the regulations, but there is something to note that in policy memorandum 21-18 about case flows, where they talk about how a case should flow, and they mention scheduling orders. Now, this policy memo should not apply to anybody applying for SIJS or to vulnerable populations, of which unaccompanied children should be considered. But that doesn't mean that scheduling orders are not being used by the immigration courts. These can be used with SIJS or vulnerable populations. And they're used generally, they're supposed to be used to make sure that matters can get sorted without having to come into immigration court. So sometimes they will ask for written pleadings, so how you plead to the factual allegations and the charges of removability. But often it is just kind of allowing you to submit your application for relief or other motions and things without having to come into court for a master calendar hearing to do that. So something to note. One other thing that I want to mention, it is common practice when if you go to observe immigration court, that when you're in a master calendar hearing, if a person is represented, their attorney will stand up, will say, we admit to the allegations and concede the charges. And I want to encourage you not to just admit and concede. I want to encourage you to make sure that you and your client are very aware of what you're admitting to and conceding to, and that they actually do apply to your client. Okay. One of the other big things that we mentioned that happens during a master calendar hearing is that if a person is going to be represented, that attorney makes an appearance at the master calendar hearing. In order to do that, you have to tell the court that you are the person representing this client. And you do that through a form called an EOIR 28, also referred to as an E28. The way you can file this, all attorneys, in order to represent, or BIA accredited representatives, in order to represent somebody in immigration court, you must have first registered on e-registry. And you can find all this information on the EOIR website and how to do it. Once you've registered, you then have to validate your identity. So prior to COVID, you were generally required to go in person to an immigration court to do this. You had to go in and stand in front of the window and show your identification, usually your driver's license and your bar card, if you had one. Now they are doing those validations via video, via WebEx. And so that's the next step. As of, I believe, the end of February, the EOIR has moved over to completely electronic filing, and their system is known as ECAS. And so the EOIR 28 should be filed online if the child you are representing has not been represented before. There can be issues filing this if they have previously been represented, and if that is the case, you need to print out an EOIR 28 on green paper and take it to the immigration court and either file it at the window, or you can do it during a master calendar hearing and give it directly to the judge. Just make sure you also have a copy for your opposing counsel, the government's attorney, and you either give it to them in open court, or you send them a copy. So let's go back again to look at the NTA, the notice to appear. So that is the document that's currently appearing on the screen. And it is a 2-page document, often front and back if it has been given directly to the client. So let's look in detail at it. On the top, it's got in the blue box a series of 9 numbers preceded by an A. This is the immigrant's identification number, or also known as an A number. And then below that, you have other detail, including date of birth. This is the first thing that you need to confirm with your client is correct, that the date of birth is correct, and that their name is correct. So those things that are in the orange box. Then you're going to see that there are 3 sentences that have checkboxes in front of them. These are the charges. What they are saying you're being charged with. So you were either an arriving alien, which means that you presented yourself to an immigration official at a port of entry and didn't necessarily have the paperwork to enter, or you are an alien present in the United States without having been admitted or paroled. This often happens when somebody has come in illegally, entered without inspection, or you have been admitted to the United States but are removable for the reasons stated below. So these are the kind of things you need to go over with your client by first checking what the allegations are. So these are the facts that are supposed to support the charge that's chosen above. And the facts here, it's, you are not a citizen of the United States, you're a native of Mexico, you arrived in the United States at a certain place in a certain time, and you were not admitted or paroled. Those are kind of the typical facts you will find. And then below that, there will be kind of the law, the specific part of the Immigration and Nationality Act, which you are supposed to have contravened, which your client was to have contravened. Then what's really important is the bottom. You can see below the date in a red box on which this NTA should have been served on you. And then also above that, it should say when your hearing is going to be. Now, this NTA says a date to be set and a time to be set. That was commonplace practice for many, many years. They didn't necessarily know when they would be able to, when the immigration court would be able to schedule it. However, there's been a series of cases recently that have come down from the Supreme Court that have strongly discouraged this practice, as it really is important that there is a proper date and time, as well as location. It also says who the officer is that served and found your client, whether they entered EV or came to the port of entry. The back part has various notices to the respondent. What's really important is that the certificate of service, especially for children, this must have been served. If it's a child and they're with their parent, it must have been served on the parent. If they are in ORR custody, it should have been served on ORR. And you will often see this kind of mark that's in a green box here that the subject refused to sign, and it was witnessed by somebody that they refused to sign. So there you go. That is what an NTA looks like. You should have received a copy of this. Your client should have received a copy of this form. You need to go over it and make sure that it is all correct. And if it is not all correct, do not admit to the allegations and concede the charges. So why am I stressing going over the NTA? Well, this kind of goes back to the burden of proof in immigration court. So first and foremost, by and large, it is the government's burden to prove alienage. So the government has the burden to prove that your client is not a US citizen. Then it shifts to the respondent, your client, to prove that the place and manner of entry was correct, or to prove eligibility for relief. So speaking of the government's burden, so DHS's burden is to prove alienage, or that the person is not a US citizen. So one of the things that they most often use is this form that's shown on the left, and it is called an I-Form 213, which is a record of deportable or admissible alien. This form provides detailed biographical information regarding the individual proceedings and the record of questioning that was conducted by the apprehending officer. So it is what is commonly used to prove alienage and to give proof for the charges in the notice to appear. Now, there is some case law that says that an I-213 is inherently reliable. It's not the best interpretation, but it is possible to move to suppress if this information was obtained. The information in the I-213 was obtained in contradiction to the Fourth Amendment. Also, the form I-213 cannot be used where a minor made admissions without representation and was unaccompanied. So just like a judge cannot accept an admission from a child that was unrepresented, even if the admission is in the form I-213, they cannot accept it. Okay. What about continuances? So your client has a hearing coming up, and you don't have, not everything is in place for you to continue this hearing. What do you do? So there are certain kind of guidelines for requesting continuances. Under the previous administration, these were restricted quite a bit. The most recent policy memo put up by EOIR about continuances was 21-13, which says it includes a non-exhaustive list of the relevant legal and policy principles as an aid to adjudicators considering the common types of continuance requests. Generally, in INA, due to INA 292, which is the right to counsel, it is fairly standard for a continuance to be given to a person who is in court without an attorney in order to seek an attorney. There is a case that allows for this to happen. Usually an unrepresented person will be given one continuance in order to find an attorney. In prior years, it was also fairly common to get a continuance for attorney preparation time or prep time. There is a case, matter of Sabrun, that agrees with this, especially if an attorney has been retained only shortly before the hearing, then you can apply for continuance. The policy memo that I mentioned says that it should be carefully considered whether or not that it's warranted. Did the attorney really have time to prepare? Should have they had time to prepare? Things like that. The other, really the main guideline as far as a continuance beyond the two circumstances I mentioned is for good cause. And this is mentioned in 8 CFR 1003.29 and 8 CFR 1240.6. However, in 2018, the Attorney General released a case that he had certified to himself called Matter of LABR, and which severely tried to limit continuances in immigration court. They did say in the case that good cause is still a reason for a continuance. But you should also know that it did not overturn some prior precedent, such as matter of Hashmi, matter of Raja, and matter of Sanchez Sosa, which allow for continuance when an application is pending with USCIS in the family-based context, an employment-based context, and in the U visa-based context. So those are still good law. Also, I would say that with the new administration, this is beginning to turn around, and that it's becoming more available. Some other options in immigration court are administrative closure and procedural discretion. Administrative closure is a tool that judges in almost all courts across the United States can use to manage their dockets. In immigration court, it was used as a way to place cases on hold when the respondents were waiting for immigration relief to be adjudicated by USCIS. That way, they didn't have to wait the court's time on master calendar hearings and adjudicating motions to continue for these individuals. Because oftentimes, if an application is pending with USCIS, that means that the immigration court does not have jurisdiction to grant that form of relief. However, in 2018, when Attorney General Sessions limited the use of administrative closure in immigration court when he certified matter of Castro Tum to himself. And he said it could only be used in cases where immigration regulations specifically authorized it, which is in the I-601A provisional waiver context. Under the Biden administration, however, Attorney General Garland overturned Castro Tum with matter of Cruz Valdez. Then EOIR explicitly authorized the use of administrative closure in DM 2203. A somewhat kind of related process, but does not come directly from EOIR, is prosecutorial discretion. It suffered a similar fate under the previous administration. Prosecutorial discretion, which is also referred to as PD, is a common law concept that allows prosecutors to determine the best way to spend their resources by choosing not to necessarily bring a case for every issue. The prior administration curbed its use by ICE, which are the government's attorneys, in the immigration context. When the new administration took office, they put out an interim memo on DHS's new enforcement priorities for those who are accused of violating US immigration law. The Texas Attorney General, joined by several other states, sued the Biden administration to stop the implementation of these priorities. Nevertheless, ICE released a memo to OPLA, Office of the Principal Legal Advisor, also known as the Trustee memo, that instructed the OPLA attorneys, which are the government attorneys in immigration court, how to use prosecutorial discretion to implement the new enforcement priorities. These enforcement priorities were ultimately enjoined, which was affirmed by the Fifth Circuit. But nevertheless, Secretary Mayorkas, the Secretary of DHS, released final guidelines that replaced the interim enforcement guidelines, which Texas and the other states quickly included in their suit. However, OPLA seems to be committed to practicing prosecutorial discretion, even outside of the enforcement guidelines context, and they have included information and instructions on their website as to how to request prosecutorial discretion. So if you are new to immigration law, but have litigated in other courts in the past, you may be wondering about pretrial conferences or their equivalent in immigration court. Immigration regulations and the immigration court practice manual allow for pre-hearing conferences. Any party can request one or file a pre-hearing statement. They are not used as frequently in immigration court as they are in typical state and federal courts. Usually the IJ will ask the parties prior to starting the individual hearing if they have talked and narrowed issues. There is also the possibility of stipulations from ICE counsel, which can be requested in advance, but are usually discussed informally between the respondent's attorney and the OPLA attorney immediately prior to the hearing. One thing to note that due to COVID, there have been quite a few changes as far as how the immigration courts are running. You do need to go check the operational status of the individual court you will be attending to make sure that they are open. Recently, during the Omicron wave, the courts went back to being closed, but they allowed for WebEx hearings, remote hearings by video. So these are different places you can check for the operational status and how to do a remote hearing in the age of COVID. So after all the master calendar hearings and all these different things we discussed, continuances, prosecutorial discretion, all that stuff has been gone through, the next step in the process, if the case has not been kind of dealt with or dismissed at this point is the individual calendar hearing or a merits hearing. This is where the judge will hear the individual's particular case. The judge will hear testimony from the respondent and any witnesses and make a decision on the case. Any applications or evidence, applications for relief, evidence for those applications, motions, witness lists, and other things like that should be submitted to the court in advance. The court will normally give you a call-up date as to when they want those things filed. This hearing takes more time than a master calendar hearing and requires quite a bit more preparation. Many call it a mini trial. We would encourage you to be prepared to make an opening statement, raise objections to the opposing party's evidence, present witnesses and evidence on all issues, cross-examine any opposing witnesses and object to testimony, and be prepared to make a closing statement. In immigration court, something that is very different for many people who have been practiced in other courts is that generally the proceeding nobody stands for the proceeding unless you're trying to approach the judge or the witness. Everything is conducted while seated. This is because the record, because of making the record, they record everything. It's an audio record. And so they need everybody to be close to the microphones that will pick up the audio for the record. However, you do get up and you do need to ask the judge to approach them or approach the witness. And you are able to use media devices, electronics, and video like we discussed before. The general flow of a merits hearing I have on the right-hand side. What's in italics means that you're not always given the opportunity to do this. So you're not always given the opportunity to make an opening or a closing, or an opening and a closing. You may be given the opportunity to do one or the other, or you may not be given the opportunity to do either. But generally, there can be an opening, and then the judge goes through and admits evidence. This is not necessarily done during the testimony. This is done at the very beginning because you have submitted all your evidence in advance, now over the ETAS portal, but usually used to submit it papers at the window or via mail. So the judge will go through and look at everything and enter it as evidence and mark them as specific exhibits. At that point, it is time to bring witnesses. So whether that be your client, other witnesses that are helpful to them, including expert witnesses, you are allowed to do direct examination on your client, but also the government attorney is allowed to do cross-examination. So that is something you need to prepare your client for, not just for the direct questions you'll be asking them, but for the cross-examination questions the government attorney might ask them. Then you will get the opportunity after all the witnesses have been presented, and the government can also present witnesses that you need to be prepared to cross-examine. After that, you may have the opportunity to present a closing, and then the judge will potentially announce their decision, and that can be oral at the end of the hearing, or it can be written and it is released after the hearing is concluded. So this can all be done in one hearing, potentially. However, depending on how many witnesses you have and how much time you need, it may end up being continued for another day. It all depends on the court's docket. So who needs to prove what when you're in removal proceedings? Really, it depends on what you are charged with, which takes us back to the checkboxes at the top of the NTA. The burden of proof changes depending on which box is checked on the NTA, which corresponds to how the individual entered the country. So the first we're going to look at is aliens are people who are present in the United States without being admitted or paroled. We do discourage the use of alien. It is rather dehumanizing, and the Biden administration has conceded this point, and they have asked their various agencies to limit the use of the word alien. It is present in the INA and the regulations, but we try to limit the use of it. So individuals who are present in the United States without being admitted paroled. So the first kind of person that has the burden is the government, as we discussed, and their burden is to prove alienage. The standard to prove alienage is not specified by regulation. And so, we don't really know what the standard is, but information on an application for relief, so if that has already been submitted, cannot be used as an admission of alienage. So that is the first burden. So once the government meets that burden, the burden then shifts to the respondent. And the respondent has to prove that they were lawfully admitted by clear and convincing evidence, or that they were entitled to be admitted to the United States, clearly and beyond a doubt. If the respondent can do that, then the government must show by clear and convincing evidence that the person is deportable. So the burden shifts to the government after that. If the government can prove alienage, then it becomes the respondent's burden to prove their eligibility for relief from removal. Okay, if the person is an arriving alien, this means that the person presented themselves to the border, to an official at the border, but didn't necessarily have the documentation in order to be able to enter the United States. The respondent has the first burden here, and they have the burden to show that they are entitled to be admitted to the United States and are not inadmissible, and that standard is clearly and beyond a doubt. Or they have the burden to prove that they're lawfully present in the United States pursuant to a prior admission by clear and convincing evidence. If somebody is deportable, so this means that they have been, they were admitted to the United States lawfully, but have since become removable from the United States for some reason. The government bears the first burden to prove that they are deportable by clear, unequivocal, and convincing evidence, which is a pretty high standard. If they can prove that, if they show that, the respondent then has the burden to rebut that evidence. Okay, so usually we get through that burden shifting, and then really the end of it is the relief, unless the person can prove that they are appropriately in the United States. So who has the burden for relief, and what is that, what standard needs to be shown? Well, in pretty much all cases, the respondent has the burden to prove their eligibility for relief. Now, the standard and what needs to be proved is different per what type of relief you are requesting. For example, asylum. The respondent, the immigrant, has the burden of proving that they have a well-founded fear of persecution. And their standard for this is the reasonable possibility standard, which means that they have a 10% chance of being persecuted. Withholding of removal, which is akin to asylum, but slightly different, they have to prove more likely than not they will be, they have a well-founded fear of persecution, which is a clear probability standard, which means more than a 50% chance of persecution. If the person is applying for adjustment of status, they have to show that it's probably true or more likely than not that they qualify to adjust status, which is the preponderance of the evidence, which is more than 50% probability. Okay, moving on now to evidence in immigration court. We're going to talk about the rules of evidence as they apply in immigration court, documentary evidence, subpoenas and depositions, and deadlines. So given that removal proceedings are administrative in nature, it has been determined that the federal rules of evidence don't necessarily apply in immigration court. Instead, evidentiary rules are governed by the INA and local rules. The sole test for admission in immigration court is relevance and fundamental fairness. So as long as the evidence is relevant and fundamentally fair, it is admissible in immigration court. The federal rules of evidence are considered more like guidelines, with the rationale that if the evidence would be admissible under the federal rules, it means that it would probably be admissible in immigration court. But just because it is not admissible under the federal rules does not mean it would not be admissible in immigration court. One of the best examples of this is hearsay. Hearsay is admissible in immigration court as long as it is relevant and not fundamentally unfair. What is kind of different is that it's the judge will decide what weight to give the evidence. If it should be noted that if you think there is evidence that should be excluded, you need to must make the substance of the excluded evidence known through a proffer. So you have to be able to tell the judge why it should not be admitted. You can move to suppress evidence, which we discussed before, so under the Fourth Amendment or the Fifth Amendment. But to prevail on a due process challenge to the exclusion of evidence, the respondent must show both that he was denied a reasonable opportunity to be heard on his evidence and that there was a resulting prejudice. The government, something else that should be known is that the government may call your client, the respondent, as a witness to establish deportability, and that requiring a respondent to testify does not violate due process in absent a valid claim of self-incrimination. There is a case that says that. And under certain circumstances, even if somebody is not testifying due to self-incrimination, the immigration judge can still draw an adverse inference from the respondent's silence. So from not testifying, which is not necessarily the case in normal in proceedings outside of immigration court. Documentary evidence. So the majority of evidence in immigration court cases is documentary evidence, and it is submitted prior to the individual hearing, and therefore, even if it's not admitted by the immigration judge, it still forms part of the record because you submitted it all prior. And there's various requirements in 8 CFR 1287.6A about admission of official documents. And just something to know that, for corroboration purposes, it's usually important to submit as much documentary evidence as possible. So, if you think it's relevant, submit it. Now, subpoenas and depositions. These are not overly common in immigration court, although they are possible. It's mentioned in the regulations and in the immigration court practice manual. The immigration judge has the exclusive jurisdiction to issue subpoenas requiring attendance of witnesses or the production of documentary evidence, and the IJ may order the taking of a deposition on her own instance or application of the party. So think here, if you're trying to do a motion to suppress, one of the reasons to suppress is because you have a right to face your accuser or the person who created the evidence against you. So you want to be able to subpoena that immigration officer or that Border Patrol officer that created the I-213, for example. However, be aware that there's something called TUI regulations for government witnesses, and you have to follow these regulations in order to compel a government witness to testify before you can get the subpoena. Okay, now let's talk about deadlines. So generally, 8 CFR 1003.31H says that the IJ may set and extend time limits for the filing of applications and documents. Now, there was a memo, a director's memo 22.04 that came out earlier this year, or last year, excuse me, saying that the default filing deadline is 15 days for anybody who is non-detained. So if the immigration judge fails to mention a call-up date in the individual calendar hearing, then your date for filing will be 15 days. If you're filing a motion to continue, for example, it needs to be filed 15 days before the date of the hearing you want to continue. So these are things to pay attention to. Make sure you're listening carefully if you're in a master calendar hearing to see what deadlines the immigration judge is setting. So just to kind of tie it all together, here's a reminder that there are special guidelines for children in immigration court. Immigration cases involving juveniles are challenging, and there is no blanket approach to all such cases. This comes from OPPM 17-03. So it goes on to say, although juvenile cases warrant special consideration in appropriate circumstances, immigration judges should also be mindful that legal requirements applicable to all immigration cases are not necessarily diminished solely because the respondent is a juvenile. So things to be aware of as far as, what can be considered in immigration court and what can be done to help make your child client more comfortable. Something to note, there is a concept of friend of the court in immigration court. This person is an aide to the court. They are not an advocate for the individual or the respondent. There are various policy memos from EYR that discuss what a friend of court can and cannot do. It superseded guidance from 2014. And there is also, if you're based in Texas, an ethics opinion as to what friend of court can do in immigration proceedings. If you end up being a friend of court, so you work for a legal service provider that helps the children that are in ORR custody. If you are an attorney and end up being a friend of court, make sure that you clarify your role with the child, that they know what you're supposed to do. But you can help the child navigate the courtroom procedures. You can gather and convey very basic information to the judge. You can explain to your client or the child you're working with about future hearings. But do not engage in anything that might confuse the child about whether or not you are their attorney. We also created a resource around ethical considerations for people appearing as friend of court. One last suggestion, prepping your client, particularly for the master calendar, the first one, the first time they go into immigration court, is just letting them know, giving them a courtroom know your rights and what to know. So who's going to be there and why, explain their roles, explain that they're being an interpreter, they're going to have to wear headphones, different things like that. When you're there, explain what's going on and what should happen when you're there, that you stand when the judge enters, that it runs on a docket, so there's going to be more than one case heard, that the judge may speak to the child individually or as a group, tell them where they're going to sit, and then what's going to happen, like what questions are the judge going to ask, the pleadings, going over the NTA in advance. Something that might help when you're giving this KYR is to explain the setup of the courtroom. This is a picture of an immigration courtroom. This is what I know this is what they look like in Houston, which is where I'm based. So you can tell the client, this is where the immigration judge is going to sit. This is where the interpreter sits. This is where the court clerk sits. TV here is here for VTC if somebody's appearing via video teleconference. You know, you're going to sit at this table, you know, whichever table that you tend to use in the courts where you're in. This is where the government attorney is going to sit. This back here is what's called the gallery. At a master calendar hearing, there will be lots of other people there. So that's just something something that can help you demonstrate to your client what's going to happen. So as we wrap up, I'd like to tell you a bit about CELA's pro bono platform called Pro Bono Matters for Children Facing Deportation, which we host on our website. There are many children and youth who do not have representation in their immigration cases and therefore must proceed alone. 17 organizations from across the country can post children's cases to our platform for children that need pro bono representation, and there are opportunities nationwide. You can use the QR code on the left to visit the platform and see what cases might be available, and you can use the QR code on the right to join CELA's newsletter about pro bono. Thank you for joining this one-on-one webinar on immigration proceedings. We hope it will serve as a good jumping off point for your own research and to give you some background so you feel more comfortable in immigration court. We also hope you'll stay connected with CELA. Please check out our resource library at cilacademy.org. You can also join a CELA working group or stay updated on our upcoming trainings. If you're in Texas, you can also reach out to us for technical assistance on individual case questions. Thanks very much.